So, a federal judge just issued a ruling so comprehensive and devastating that it didn't just reject Trump's latest legal maneuver, it systematically dismantled every single fallback position his legal team had been developing. And let me tell you, the 92-page opinion reads like a point-by-point destruction of Trump's entire defense strategy. We're talking about a ruling that anticipated every argument Trump's lawyers might make on appeal, addressed every procedural escape route they've been plotting, and closed off every delay tactic they had left in their playbook. It's honestly hard to believe we're watching a federal judge essentially predict and preemptively block every move Trump's legal team was planning to make over the next 6 months. This isn't just one legal setback or a temporary delay in Trump's plans. We're talking about a decision that fundamentally reshapes the timeline of this case and eliminates Trump's primary defense strategy and sets up a trial that Trump's team has been desperately trying to avoid. The legal reasoning is bulletproof, the factual findings are damning, and Trump's options for fighting back just shrunk dramatically. Here's the scoop on what's going down because this ruling changes everything. So, Donald Trump has been fighting special counsel Jack Smith's federal election interference case with an increasingly complex web of legal strategies. After his initial presidential immunity claims ran into trouble at the Supreme Court, Trump's legal team pivoted to what they called a multi-layered defense approach. This wasn't just about immunity anymore, it was about challenging Jack Smith's authority to prosecute the case, arguing that the indictment itself was constitutionally defective, claiming various evidence should be suppressed, and filing motions to dismiss based on selective prosecution, vindictive prosecution, and First Amendment grounds. Trump's lawyers had essentially created a legal maze designed to force Judge Tanya Chutkan to rule on dozens of complex issues, each one requiring extensive briefing, each one creating opportunities for appeal, and each one buying Trump precious time. From the beginning of November 2024, Trump's strategy has been absolutely clear. File so many motions with such complex legal issues that no judge could possibly resolve them all before the 2024 election. Whether it was challenging the appointment of Jack Smith as special counsel, arguing that Trump's January 6th speech was protected political speech under the First Amendment, claiming that the prosecution was selective and politically motivated, or demanding extensive discovery about the Justice Department's decision-making process, Trump's legal team really cemented themselves as masters of legal obstruction disguised as legitimate defense. They've been filing motion after motion, each one with hundreds of pages of supporting briefs, each one citing obscure legal precedents, and each one framed as raising fundamental constitutional questions that deserve careful consideration. But here's where the rubber meets the road. Judge Tanya Chutkan has been presiding over this case since August 2023, and she's heard every delay tactic, read every inflated legal brief, and seen through every attempt to turn legitimate legal issues into months of litigation. She's presided over dozens of January 6th cases. She knows the facts of that day intimately, and she's developed a keen sense for when lawyers are raising genuine legal issues versus when they're just trying to run out the clock. On November 15th, Judge Chutkan did something that caught Trump's legal team completely off guard. She issued a comprehensive omnibus ruling addressing not just the pending motions before her, but also the anticipated motions Trump's team had signaled they planned to file. Reports from legal analysts who've reviewed the 92-page opinion revealed just how thorough Judge Chutkan was. In dismantling Trump's legal strategy, she didn't just rule on the motions in front of her, she systematically addressed the entire universe of arguments Trump's team had made, or hinted at making, explained why each one failed as a matter of law, and established a factual record that would make it extremely difficult for Trump to succeed on appeal. According to Politico, as detailed analysis published November 16th, Judge Chutkan's ruling addressed 12 separate legal issues, rejected every single argument Trump's team made, and did so with such detailed legal reasoning that appellate courts would have little room to second-guess her conclusions. Talk about comprehensive. Essentially, Judge Chutkan was not just deciding the motions before her, she was closing off every avenue of delay, and forcing this case toward trial. Whether Trump liked it or not, this ruling sent shockwaves through Trump's legal and political operation because it raised fundamental questions about their entire strategy. If Judge Chutkan had anticipated and blocked every legal maneuver they'd been developing, including ones they hadn't even formally filed yet, what was left? How could they delay the trial now? What arguments could they make on appeal that the judge hadn't already addressed and rejected? Now, this isn't the first time we've seen Trump's delay tactics systematically rejected by a judge who's done their homework. Trump's legal strategies really only work when judges are willing to give him the benefit of the doubt, grant extensions, and treat every motion as raising novel issues deserving extended consideration. Whenever judges treat Trump's filings with the same skepticism they'd apply to any other defendant trying to delay their trial, his strategies fall apart. We've spotted this pattern time and time again. Just think about how Judge Arthur Engoron handled Trump's civil fraud trial in New York. Trump's lawyers tried every delay tactic in the book: motions to dismiss, requests for postponement, claims the case should be moved to a different venue, arguments that the statute of limitations had expired. Judge Engoron systematically rejected each one, kept the trial on schedule, and eventually issued a ruling finding Trump liable for massive fraud and imposing hundreds of millions of dollars in penalties. Trump's delay tactics didn't work because the judge refused to play along. Then there was Judge Lewis Kaplan in the E. Jean Carroll defamation cases. Trump's legal team wasn't pleased when Judge Kaplan refused to delay the trial just because Trump was campaigning for president. When Trump's lawyers argued he was too busy with campaign events to attend trial, Judge Kaplan made clear the trial would proceed with or without Trump present. When Trump's team filed last-minute motions trying to introduce new evidence or change legal strategies, Judge Kaplan rejected them as untimely. The result? Two trials that proceeded on the court schedule, not Trump's, resulting in judgments totaling over $88 million against him. And let's not forget how Judge Beryl Howell handled grand jury matters in the early stages of the January 6th investigation. When Trump's lawyers tried to assert executive privilege to prevent testimony from White House officials, Judge Howell rejected those claims and ordered witnesses to testify. When Trump and his team tried to delay compliance with subpoenas through procedural motions, Judge Howell imposed tight deadlines and threatened sanctions. Her unwillingness to tolerate delay tactics helped ensure the investigation proceeded efficiently despite Trump's obstruction attempts. Even in the classified documents case, before Judge Eileen Cannon took some controversial positions favorable to Trump, the initial proceedings showed how Trump's delay tactics can be shut down by firm judicial management. The initial search warrant was executed swiftly. The special master appointment that Trump sought was eventually overturned by the 11th Circuit, and the case moved forward despite Trump's efforts to slow it down. Now, it looks like Judge Chutkan is following this same pattern of refusing to let Trump manipulate the judicial process. This approach is becoming all too familiar to Trump's legal team. You can file all the motions you want and make all the legal arguments you can imagine. But the moment a judge sees through the delay tactics and refuses to play along, your entire strategy collapses without warning. So what did Trump's legal team do to trigger this comprehensive smackdown from Judge Chutkan? Well, it all boils down to overreach and underestimating the judge. The legal impasse happened because Trump's lawyers wanted to litigate every conceivable issue in this case, from the fundamental authority of the special counsel to the admissibility of specific pieces of evidence, while Jack Smith's prosecution team was trying to move directly to trial on the straightforward question of whether Trump committed the crimes charged. Ultimately, the case had been stalled in pretrial litigation for months since Trump's team kept filing new motions and the court had to rule on each one before proceeding. As the defendant's legal team, Trump's lawyers decided to take a shotgun approach, throw everything at the wall and see what sticks. They filed a motion to dismiss based on special counsel Jack Smith's appointment being unconstitutional, challenged the indictment as unconstitutionally vague, argued the prosecution violated Trump's First Amendment rights, claimed selective and vindictive prosecution, demanded extensive discovery about the Justice Department's decision-making, and signaled they intended to file additional motions challenging the admissibility of evidence and seeking to sever different counts for separate trials. Their approach seemed to be just to create so many complex legal issues that the judge couldn't possibly resolve them all quickly, and even if she ruled against them, and they'd have multiple issues to appeal. At first, this strategy seemed like it might work. Trump appreciates lawyers who fight on every front, and the notion of having multiple pending motions creates the appearance of a vigorous defense. While actually serving the goal of delay, the legal issues raised weren't completely frivolous. Some of them, like the special counsel appointment question, had at least colorable legal arguments, even if they were ultimately unlikely to succeed. But here's where things started to go wrong. as Trump's legal team kept filing motion after motion throughout October and early November. Judge Chutkan started seeing the pattern. She recognized that many of these motions were interdependent. The answer to one question affected the others. She realized that if she ruled on them piecemeal, Trump's team would just appeal each ruling separately, creating months or years of appellate litigation, and she understood that some of the forthcoming motions Trump's team had previewed were designed purely to delay raising issues that could have been raised months earlier, but were being held back to create additional rounds of briefing. According to legal experts who reviewed the docket, Judge Chutkan made a strategic decision. Rather than rule on each motion as it was fully briefed and then wait for the next one, she would issue a comprehensive omnibus ruling addressing all pending and anticipated motions at once. This would create a complete record for appeal, prevent piecemeal appellate litigation, and force Trump's team to either appeal everything at once or abandon the weaker arguments. While Trump's lawyers were still working on their reply briefs for some motions and preparing to file others, Judge Chutkan was already preparing to cut the ground out from under their entire strategy. Now, here's the kicker. Judge Chutkan didn't just reject Trump's arguments, she anticipated them. According to CNN's legal analysts who've studied the ruling, Judge Chutkan addressed arguments of Trump's lawyers hadn't even formally made yet. She could tell from their preliminary filings and oral arguments what direction they were heading, and she shut down those lines of argument before they could be fully developed. It's like a chess master who sees their opponent's strategy developing and makes moves that counter not just the current position but the next 5 moves the opponent was planning. Trump's lawyers thought they were being clever by spacing out their motions and holding some arguments in reserve. What they didn't realize was that Judge Chutkan had already figured out their entire playbook. Let me break this down because the ruling is so comprehensive, it's worth understanding exactly what Judge Chutkan did. On the special counsel appointment challenge, Trump's team had argued that Jack Smith was unconstitutionally appointed because he wasn't confirmed by the Senate and because the special counsel regulations violate the appointments clause. This argument had some surface appeal because it cited constitutional provisions and legal precedents about how federal officers must be appointed. Judge Chutkan devoted 15 pages to demolishing this argument. She pointed out that special counsels are inferior officers, not principal officers, requiring Senate confirmation. She cited the Supreme Court's Morrison v. Olson decision, upholding the independent counsel statute. She noted that special counsels have been used for decades under both Republican and Democratic administrations without constitutional challenge. And she pointed out that Trump himself had special counsels appointed during his administration and never questioned their constitutional authority. But then she went further. Judge Chutkan anticipated that Trump's team might try to distinguish this case by arguing Jack Smith has more independent authority than previous special counsels, so she preemptively addressed that argument, explaining why even under a broader interpretation of what requires Senate confirmation, special counsels still qualify as inferior officers subject to supervision by the Attorney General. She cited internal Justice Department documents showing the chain of command and oversight. She essentially made it impossible for Trump to appeal this issue successfully because she'd already addressed every argument he could make. On the First Amendment challenge, Trump's team had argued that his January 6th speech and his broader election challenge were protected political speech that cannot be criminalized. This is one of Trump's favorite arguments because it resonates with his supporters. The idea that he's being prosecuted for exercising free speech. Judge Chutkan spent 20 pages explaining why this argument fails. She distinguished between protected political speech and criminal conduct. She pointed out that fraud, conspiracy, and obstruction of official proceedings don't become legal just because you accomplish them through speech. She cited cases making clear that the First Amendment doesn't protect speech, that so is part of criminal conduct, like fraud schemes, threats, or solicitation of crimes. She then walked through the indictment count by count, showing how each charge was based on conduct, not just speech. Trump's not charged with giving a speech or expressing opinions about election fraud. He's charged with knowingly making false statements to obstruct official proceedings, conspiring to defraud the United States through a scheme involving fake electors, and obstructing Congress's constitutional function of counting electoral votes. The speech is evidence of the criminal intent and the criminal agreements, but the crimes themselves are the actions taken in furtherance of those agreements. And here's where Judge Chutkan really showed her strategic thinking. She anticipated Trump's team would argue on appeal that the judge didn't properly analyze the specific speech at issue, so she included detailed analysis of Trump's actual statements explaining which ones showed criminal intent, which ones were part of the conspiracy, and which ones demonstrated Trump knew his election fraud claims were false. She created such a thorough, factual record that an appellate court would have no basis to second-guess her conclusions. On the selective prosecution claim, Trump argued he was being singled out for prosecution based on his political views, while others who made similar challenges to elections weren't prosecuted. Judge Chutkan spent 10 pages destroying this argument. She explained the legal standard for selective prosecution. You have to show both that you were treated differently from similarly situated people and that the prosecution was based on an impermissible motive, like race or political viewpoint. Then she methodically showed why Trump couldn't meet the standard. First, Trump isn't similarly situated to other people who challenged election results. Other politicians filed lawsuits, which is legal, and they requested recounts, which is legal. They made political arguments about election integrity, which is protected speech. Trump is charged with organizing a criminal conspiracy involving fake electors, pressuring state officials to falsify vote counts, and inciting a violent attack on the Capitol to prevent the certification of electoral votes. No other politician in modern American history has done anything remotely similar. Judge Chutkan cited specific facts from the indictment showing the unique nature and scope of Trump's alleged conduct. She pointed out that even during the contested 2000 election, Al Gore didn't organize fake electors or pressure state officials to fabricate votes. Even candidates who believed they were cheated worked through legal channels. Trump's alleged conduct is qualitatively different from any previous election challenge. Second, even if Trump could show differential treatment, he had no evidence of impermissible motive. The Justice Department appointed a special counsel specifically to ensure the prosecution was independent and free from political influence. The indictment was brought by a grand jury of ordinary citizens who reviewed evidence. The charges are based on well-established criminal statutes, not novel legal theories invented to target Trump, but Judge Chutkan didn't stop there. She anticipated Trump would appeal this issue by pointing to statements by Democratic politicians criticizing him or calling for accountability. So she explained why such statements are irrelevant. What matters is whether the prosecutors bringing this specific case were motivated by impermissible factors. And there's no evidence they were. She even cited cases making clear that public criticism of a defendant doesn't prove selective prosecution. On the vindictive prosecution claim, the argument that Trump was being prosecuted in retaliation for exercising his legal rights, Judge Chutkan was even more dismissive. She explained that vindictive prosecution requires showing the prosecution was motivated by the defendant's exercise of protected rights, like demanding a trial or appealing a conviction. Trump's theory seemed to be that he was being prosecuted in retaliation for running for president again or for challenging the 2020 election, but as Judge Chutkan pointed out, the investigation began before Trump announced his 2024 campaign. The conduct being prosecuted occurred in 2020, 2021, and there's no evidence the decision to prosecute was based on anything other than the evidence of criminal conduct. You can't claim vindictive prosecution when you're being prosecuted for crimes you allegedly committed before you exercised. Whatever right you claim triggered the retaliation. Let's break this down further because Judge Chutkan's ruling gets even more devastating. On evidentiary issues, Trump's team had previewed arguments that certain evidence should be excluded, particularly communications involving lawyers, claiming attorney-client privilege, and evidence from White House witnesses, claiming executive privilege. Judge Chutkan devoted a section of her ruling to these issues, even though formal motions hadn't been fully briefed yet. She explained that the crime-fraud exception defeats attorney-client privilege when communications were in furtherance of criminal conduct. She noted that executive privilege has already been litigated extensively in this case, with courts consistently ruling it doesn't apply to criminal investigations, and she pointed out that Trump had already lost these privilege battles in the grand jury stage. So relitigating them now would be an abusive process. By addressing these issues preemptively, Judge Chutkan made clear she wouldn't entertain extensive motion practice on evidence that had already been determined to be admissible. This cut off another avenue Trump's lawyers were planning to use for delay on the vagueness challenge, Trump's argument that the criminal statutes he's charged under are unconstitutionally vague. Judge Chutkan was almost dismissive. She explained that criminal statutes are unconstitutionally vague only if they don't give fair notice of what conduct is prohibited and the statutes Trump is charged under. Conspiracy to defraud the United States, obstruction of an official proceeding, conspiracy against rights have been used for decades and have clear, well-established meanings. She cited numerous cases applying these statutes in contexts similar to Trump's alleged conduct. Then she made a point that must have stung Trump's legal team. She noted that Trump's own Justice Department prosecuted people under these exact statutes during his presidency. If the statutes were unconstitutionally vague, Trump's own administration was using them improperly. The argument that they're suddenly vague now that Trump is charged under them is legally incoherent. On the outrageous government conduct claim, an argument Trump's team had hinted at without fully developing, Judge Chutkan shut it down preemptively. This defense applies when the government's conduct in investigating and prosecuting a case is so outrageous it violates due process. Trump's team had suggested the investigation was politically motivated, leaked information to the press, and coordinated with Congress's January 6th committee. Judge Chutkan explained that none of these allegations, even if true, would constitute outrageous government conduct under established legal standards. Investigations of public officials naturally attract media attention. Parallel congressional and criminal investigations are common and legally permissible. Absent allegations of fabricated evidence, false testimony, or denial of basic due process rights, there's no outrageous government conduct to claim. Here's where it gets really interesting. Judge Chutkan's ruling didn't just address legal arguments, it made extensive factual findings that will bind Trump on appeal. Federal appellate courts review legal conclusions de novo, meaning they give no deference to the trial judge and decide legal questions fresh, but they review factual findings for clear error, meaning they'll only overturn the trial judge's factual conclusions if no reasonable judge could have reached them based on the evidence by making detailed factual findings in this ruling. Judge Chutkan created a record that will be very hard for Trump to overcome on appeal. For example, she made factual findings that Trump knew his election fraud claims were false because his own campaign advisors, attorneys, and administration officials repeatedly told him there was no evidence of fraud sufficient to change the outcome. She found that Trump's pressure on state officials went far beyond legal challenges and constituted corrupt attempts to overturn certified election results. She found that the fake elector scheme was not a legitimate legal strategy but a fraudulent effort to create false documentation. She found that Trump's actions on January 6th were designed to obstruct Congress's constitutional function, not to protect election integrity. Each of these factual findings is supported by extensive citations to evidence in the record witness testimony, documents, Trump's own statements, and contemporaneous communications. An appellate court reviewing these findings would have to conclude Judge Chutkan was clearly wrong about the evidence, which is an extremely high bar to meet. According to legal experts interviewed by MSNBC, this is one of the most strategically brilliant aspects of Judge Chutkan's ruling by making factual findings. Now, before trial, she's essentially locked in certain facts that will apply throughout the case. Trump can't credibly argue on appeal that the judge was biased or rushed to judgment when she supported every conclusion with detailed citations to evidence. He can't claim the factual record is incomplete when she reviewed thousands of pages of documents and grand jury testimony. The ruling also addressed Trump's likely appellate strategy. Judge Chutkan clearly anticipated that Trump would try to appeal this ruling immediately, attempting to delay the trial during the appellate process. So she included language and making clear that her ruling is not a final appealable order because it doesn't dispose of the entire case, it just resolves pre-trial motions. Under federal law, you generally can't appeal pre-trial rulings until after the trial is complete and a final judgment is entered. There are exceptions for certain types of orders, but Judge Chutkan carefully structured her ruling to avoid those exceptions. She also noted that even if Trump tries to seek emergency appellate relief through a petition for mandamus, asking an appellate court to order her to change her ruling, such petitions are rarely granted, and only when the trial judge has clearly exceeded her authority by providing such detailed legal reasoning for every conclusion. She made it nearly impossible for Trump to show she exceeded her authority, but here's what you need to understand. The most devastating part of this ruling isn't any single legal conclusion. It's the totality of what Judge Chutkan accomplished. She resolved virtually every pretrial issue in one comprehensive ruling. She anticipated and blocked every delay tactic Trump's team was developing. She created a factual record that will be nearly impossible to overcome on appeal. She structured the ruling to prevent immediate appellate review, and she set a clear path to trial that Trump can no longer obstruct through procedural motions. In one 19-page opinion, Judge Chutkan essentially said, I see what you're doing. I understand your strategy. I've addressed every argument you've made and every argument you were planning to make. Now we're going to trial. Trump's legal team must have felt like they'd been playing checkers, while Judge Chutkan was playing three-dimensional chess. They thought they were being clever by spacing out their motions and holding arguments in reserve. And what they didn't realize was that the judge was 10 steps ahead of them the entire time. Now, this left Trump's legal team in an impossible position. On one side, they need to appeal this ruling to have any hope of delaying the trial and satisfying Trump's demand for aggressive defense. Trump expects his lawyers to fight every ruling and never accept defeat if they don't appeal. Trump will view it as giving up and will likely blame them for the case moving forward. On the flip side, they have to figure out how to appeal a ruling that's been specifically crafted to be appeal-proof. Judge Chutkan addressed every possible argument, created a comprehensive factual record, and structured the order to avoid immediate appellate review. Even if they file an appeal, their chances of success are minimal, and the appellate process won't stop the trial from proceeding. The tricky part is there's no good option. If they appeal and lose, they've wasted time and money on a futile effort and demonstrated that their legal arguments don't hold up even on appeal. If they don't appeal, Trump will blame them for not fighting hard enough, and they'll face the trial without having exhausted their appellate options. Either way, the trial is coming, and it's coming soon. It's a complete strategic disaster. And that's exactly what Judge Chutkan intended. She wanted to put Trump's team in a position where they had no good moves left, where every option was bad, and where the path to trial was clear and unavoidable. This whole scenario is causing absolute panic within Trump's legal and political operation. If Judge Chutkan has systematically blocked every legal maneuver and forced the case toward trial, every Trump advisor is left wondering what the plan is now. Those more experienced lawyers on Trump's team who understand how devastating this ruling is are worried about facing trial with their pre-trial defenses completely rejected. They know that going to trial after the judge has already made factual findings against you, ruled that your legal theories are meritless, and created a comprehensive record supporting the prosecution is about the worst possible position to be in. Meanwhile, the Trump loyalists who view all of this as political persecution are pushing for even more aggressive tactics. They want Trump to attack Judge Chutkan personally, to claim the entire proceeding is illegitimate, and to use the trial as a political platform rather than trying to win on the legal merits. They're arguing that since the legal route has failed, Trump should go full political warfare. Things became even more intense when reports emerged that Trump's legal team had an emergency meeting at Mar-a-Lago the day after the ruling was issued. According to sources who spoke to the New York Times, the meeting devolved into heated arguments between different factions of Trump's legal team. Some lawyers argued they needed to accept reality, prepare for trial, and focus on developing a defense that might actually persuade jurors. Other advisors insist and continue the delay tactics even if they're unlikely to succeed. Trump himself reportedly oscillated between rage at the ruling and denial that it matters, at one point insisting the case would go away once he wins the election, despite his lawyers explaining that winning the election won't make federal criminal charges disappear. When Trump's own legal team can't agree on basic strategy and is having screaming matches at emergency meetings, the situation has spiraled out of control. The lawyers are supposed to present a united front and execute a coherent strategy, but instead they're fracturing into competing camps with fundamentally different approaches to the case. Legal experts watching this unfold have been uniformly impressed by Judge Chutkan's ruling. Neil Katal, former acting Solicitor General and a Supreme Court advocate with extensive appellate experience, appeared on MSNBC and stated, "This is one of the most comprehensive and strategically brilliant judicial opinions I've seen in a pre-trial criminal case. Judge Chutkan didn't just rule on the motions before her. She anticipated Trump's entire appellate strategy and defused it. She's made it extraordinarily difficult for him to succeed on appeal, and nearly impossible to delay the trial further. This is what happens when a highly skilled judge gets tired of delay tactics and decides to cut through all the nonsense. Barbara McQuaid, former U.S. attorney and law professor, wrote in an analysis piece, Judge Chutkan's omnibus ruling is a masterclass in judicial efficiency and strategic thinking by addressing all pending and anticipated motions in one comprehensive order. She's compressed what could have been months or years of piecemeal litigation into a single appeal. By making detailed factual findings, she's created a record that will be nearly impossible to overcome on appeal, and by carefully structuring the order to avoid immediate appealability, she's ensured the trial can proceed even if Trump attempts appellate review. This ruling should be taught in law schools as an example of how judges can maintain control of their dockets despite aggressive delay tactics. Even some conservative legal commentators acknowledge the strength of Judge Chutkan's ruling. While they might disagree with the prosecution itself, they recognize that the judge's legal reasoning was sound and her strategic approach was effective. When legal experts across the political spectrum agree that a ruling is comprehensive, well-reasoned, and strategically brilliant, that's a clear sign that Trump's legal team just suffered a devastating defeat. So let's break down what this ruling actually means for the case going forward because the implications are enormous. First, the immediate timeline. Judge Chutkan included in her ruling a clear statement that, with all pretrial motions now resolved, the case will proceed directly to trial preparation. She set a trial date of February 3rd, 2025, giving both sides approximately 2.5 months to prepare. This timeline is aggressive but not unreasonable given that the case has already been pending for over a year and much of the evidence has already been disclosed through discovery. For Trump, this is devastating. He's been trying to delay the trial until after the 2024 election, hoping that if he wins the presidency, he can make the federal charges disappear by appointing a loyalist attorney general who will dismiss them by attempting to pardon himself. A February 2025 trial date means Trump will potentially be on trial during the critical early presidential primary season. He could be sitting in a federal courtroom while his opponents are campaigning in Iowa, New Hampshire, and South Carolina. The optics of a presidential candidate defending himself against federal charges of attempting to overthrow American democracy during the height of the primary campaign are politically catastrophic. And honestly, that's not what Trump wanted. He's built his political brand on appearing strong, victorious, and persecuted by unfair enemies, sitting in a courtroom as a criminal defendant, being bound by judicial rules about what he can say and do, having prosecutors present evidence of his alleged crimes to a jury. That's the opposite of the image he wants to project. Most voters, even those who support Trump politically, have at least some respect for the judicial process and the rule of law. Watching a presidential candidate unable to campaign because he's on trial for attempting to subvert democracy creates a powerful narrative that Trump committed serious crimes and is finally facing accountability. Now, let's touch on what this means for Trump's appellate options, which are now severely limited. Trump can attempt to appeal Judge Chutkan's ruling, but he faces significant obstacles. First, the ruling isn't immediately appealable as a final order because it doesn't dispose of the entire case. Trump would need to either wait until after trial to appeal or seek permission for an interlocutory appeal, which requires showing exceptional circumstances. Second, even if he gets appellate review, Judge Chutkan's ruling is so comprehensive and well-reasoned that his chances of success are minimal. She addressed every legal argument with detailed analysis and extensive citations to controlling precedent. She made factual findings supported by extensive evidence. An appellate court would have little basis to overturn her conclusions. Third, the D.C. Circuit Court of Appeals, which would hear Trump's appeal, has already ruled against him multiple times in related matters. The D.C. Circuit rejected his immunity claims, rejected his executive privilege claims, and consistently ruled that the January 6th investigation was legitimate and proper. There's no reason to think they'll suddenly reverse course and accept arguments Judge Chutkan has already thoroughly debunked. Fourth, even if Trump appeals, the appeal won't automatically stop the trial from proceeding. He would need to obtain a stay of the trial proceedings, which requires showing a likelihood of success on appeal and irreparable harm from proceeding to trial. Given the strength of Judge Chutkan's ruling, Trump can't show likelihood of success. And courts have consistently held that having to stand trial is not irreparable harm. If you win on appeal later, you can get relief at that point. This situation shines a massive spotlight on the fundamental issue at the heart of this case, whether former presidents can be held criminally accountable for their actions or whether they're effectively above the law. For 250 years in American democracy, the principle has been that no one is above the law, not even the president. Former presidents can be investigated, prosecuted, and convicted if they commit crimes. And the criminal justice system doesn't pause because someone is politically powerful or running for office. But Trump has consistently challenged this principle. He's argued that presidents have absolute immunity for official acts, that prosecuting a former president is politically illegitimate, that the criminal justice system is being weaponized against him, and that he should be exempt from prosecution because he's running for office again. Judge Chutkan's ruling is a comprehensive rejection of these claims. She's made clear that Trump, like any other defendant, must answer to the criminal justice system. He's not above the law. His political status doesn't exempt him from prosecution, and the courts won't allow him to manipulate the judicial process to avoid accountability. If this ruling stands, it establishes a crucial precedent that even presidents and former presidents are subject to the rule of law, that future leaders cannot commit crimes with impunity by claiming official authority, that the criminal justice system can hold powerful political figures accountable without being dismissed as politically motivated. So the implications of this ruling reach far beyond just Trump's case. It's about shaping constitutional accountability for generations to come. Each time Trump tries to place himself above the law and gets rejected by courts, it strengthens the principle that rule of law applies to everyone. It starts establishing a pattern that future presidents will understand you can't escape accountability through procedural manipulation, political pressure, or claims of special status. Think about it. If Trump can delay indefinitely through endless pre-trial motions, what's to stop the next president accused of crimes from doing the same? If former presidents can claim immunity for any action connected to their official duties, what limits exist on presidential power? If wealthy, politically connected defendants can manipulate the justice system through aggressive lawyering and procedural tactics, what does that say about equal justice under law? These aren't hypothetical questions. Every future president will look at how Trump's case was handled as a model for what they can and cannot do if Trump successfully escapes accountability through delay tactics and political pressure. Future presidents will know they can do the same. But if Trump faces trial, conviction, and consequences despite his wealth, political power, and aggressive legal tactics, future presidents will understand that criminal accountability is real even for them. Looking ahead to the trial itself, Trump faces an incredibly difficult path. He's going into trial after the judge has already rejected his legal defenses, made factual findings against him, and created a comprehensive record supporting the prosecution's case. His lawyers will have to find a way to persuade jurors. Despite all of this, the prosecution has a significant advantage. They have extensive evidence, documents, testimony from Trump's own advisors and lawyers, Trump's own statements and tweets, video evidence from January 6th, and testimony from state officials Trump pressured. They have a coherent narrative. Trump knew he lost the election, was told repeatedly by his own people that his fraud claims were false, and nonetheless orchestrated a multi-part conspiracy to overturn the results anyway. And they have Judge Chutkan's ruling establishing that Trump's defenses lack legal merit. Trump's defense will likely focus on his state of mind, arguing that he genuinely believed the election was stolen, that he was relying on advice from lawyers, and that his actions were motivated by sincere concerns about election integrity rather than criminal intent. But this defense faces serious problems. First, there's extensive evidence that Trump was told by his own advisors, lawyers, and officials that his fraud claims were false. Second, Trump's actions went far beyond expressing concerns or filing lawsuits. He organized fake electors, pressured state officials to fabricate votes, and incited a violent attack on the Capitol. Third, even if Trump believed the election was stolen, that doesn't justify criminal conduct to overturn it. So expect the trial to be a grueling, detailed examination of Trump's conduct in the weeks after the 2020 election. The prosecution will present witness after witness, former White House officials, campaign advisors, lawyers, state election officials, all testifying about what Trump knew, what he was told, and what he did anyway. They'll show internal communications, play recordings like the Georgia call, and present evidence of the fake elector scheme. They'll build a comprehensive picture of a president who knew he lost, was told he had no valid legal challenges, and chose to pursue criminal means of retaining power anyway. Trump himself will face a difficult decision about whether to testify. If he testifies, he'll be subject to cross-examination, where prosecutors can confront him with his own statements, force him to explain contradictions, and potentially catch him in lies. If he doesn't testify, the jury will only hear the prosecution's evidence without his side of the story. Either option is risky, and given Trump's tendency to ramble, go off script, and make incriminating statements, his lawyers will almost certainly advise him not to testify. But Trump often ignores legal advice in favor of his political instincts, and he may insist on testifying despite the risks. So here's the deal. A federal judge just issued a 92-page ruling that systematically destroyed every element of Trump's legal strategy, anticipated and blocked every delay tactic his team was planning, and set a clear path to trial that Trump can no longer obstruct. This isn't just one adverse ruling that Trump can overcome on appeal or work around with new motions. It's a comprehensive dismantling of his entire approach to the case. If this ruling stands, Trump will face trial in February 2025 on charges of attempting to overthrow American democracy during the height of the presidential primary season, with his legal defenses already rejected by the judge and a prosecution armed with extensive evidence of his alleged crimes. It's about so much more than just this one case. It's about whether our constitutional system can hold even the most powerful political figures accountable for criminal conduct, or whether wealth, political power, and aggressive legal tactics can place someone above the law. Judge Chutkan has made clear that in her courtroom, and no one is above the law, not even former presidents. So keep an eye on this, because what happens next will define American democracy for generations. Trump's legal options are running out. The trial is approaching rapidly, and the possibility that he'll face criminal accountability for attempting to overturn an election is becoming very real. The next few months are going to be absolutely crucial. Stakes have never been higher, and the evidence never stronger, and the path to accountability never clearer. This ride is far from over. But Trump just lost control of the steering wheel, and Judge Chutkan is driving this case straight toward trial.